Good afternoon, ladies and gentlemen. It's Tuesday, March 21st, 2023. Welcome to Civil Justice Subcommittee. Madam Clerk, take the roll.
Good afternoon. Representatives Beck, Bolso, Capley, Eldridge, Farmer, Grills, Lamberth, Parkinson, Todd, Chairman Russell. Chairman, you have a quorum.
Thank you. Members, any personal orders this morning or this afternoon? I do have one special personal order this afternoon, and that is Representative Beck.
Yes, sir.
It's your birthday, and we want to wish you a happy birthday. And so we've got hats. If y'all will just take this and pass it down. And we got you a blue one. We got you a. Hey.
I think Rick needs a hat.
Chairman Farmer, you're recognized.
Hey, and members, I'm going to make one motion that the motion is that Representative Beck wear his hat while he's presenting his bill.
I second that.
I
think that's
Okay.
fitting for today.
Yeah.
All right, we've got a calendar here. Oh, Gino didn't get a hat. We'll give you a red one, Gino.
He's gonna feel left out.
All right. All right, item number one. You're welcome. Happy birthday. Item number one, House Bill 26 has been referred to criminal justice. Item number two, House Bill 1346, we'll roll it to the Hill. That brings us to item number three, House Bill 1259 by Representative Vital. We got a motion and a second. Representative Vital, you are recognized. I'm showing an amendment. Would you like to run that amendment?
I would. Drafting code 3741, and it makes the bill.
That's what I got. We got a motion and a second. All in favor for adding amendment 37412 to House Bill 1259, signify by saying aye. Aye. Opposed, no. Amendment added. You are recognized.
Thank you, Mr. Chairman. Members of the committee, I really hate to use the phrase, this is a simple bill, when I have lawyers in the room, but I'm learning very quickly. But this is a very simple bill from my understanding. This bill prevents a tenancy by the entirety in real property from being assigned or severed, or a spouse's interest in such real property conveyed to a third party without the other spouse's written consent or a court order. With that, I renew my motion.
Any questions for the sponsor? Representative Beck.
Thank you, Mr. Chairman. Now, under present law, a spouse can negate their right to spousal interest, but in your bill, that will no longer be permitted?
Representative Vital.
Mr. Chairman, I would have to ask legal to answer that question.
Would you like to go out of session, Representative Beck?
We're on number 3.
Without objection, we'll go out of session. Hear from legal. Legal, you're recognized.
Michelle Fogarty, Legal Services. If this bill becomes law, then spouses that own property as a tenancy by the entirety would not, one spouse would not be able to sever that tenancy without the other spouse's consent or a court order.
Representative Beck.
I see this a lot in estate planning and other different types of tax planning. So under this bill, they would no longer be able to sever the spouse's interest in such a document. Is that correct, legal?
Legal, you're recognized.
Not without the consent of the other spouse.
Representative Beck.
So they can still do it with the consent of the other spouse?
They have to do it with the written consent of the other spouse.
And that has to be filed with the document at the registrar's office, I would take it.
I would assume so.
Very good. Okay, we're good. Thank you.
Any other questions for legal? Seeing none, we'll go back in session. Sponsor, you're recognized.
Thank you. And for those who may want the definition of what tenancy by the entirety is, it's a legal arrangement where a married couple shares equal ownership of property, and ownership automatically passes to the survivor if the partner dies or transferred by written consent.
Thank you. Seeing no other questions, we're voting to send House Bill 1259 to civil full. All those in favor signify by saying aye. Opposed, no. Civil full. Next up, item number 4, House Bill 1466 by
Thank you,
Representative
committee.
Towles. Thank you. Do I have a motion? Do I have a second? We got a motion and a second. Representative Towns, you are recognized. And he's not here. All right, we can need to Representative Todd, Chairman Todd.
I move to put this on next year's calendar.
That's a proper motion. Do we have a second? We're voting. We got any objections? We would have to vote on the motion first, so. All those in favor for sending House Bill 1466 to next year's calendar signify by saying aye. Opposed, no. The ayes prevail. Next up, item number 5, House Bill 1237. Do we have a motion or a second? Motion. We got a motion. We've got an objection. So we got a motion to roll to the hill. All those in favor signify by saying aye. Opposed, no. No's prevail. We got a motion. We got a motion and a second, send to summer study for House Bill 1237. All in favor signify by saying aye. Opposed, no. Ayes prevail. Next up is item number 6, 1349 has been taken off notice.
Mr. Chair, may I say just one thing before we
Absolutely.
take that
Chairman
off
Farmer,
notice?
you're recognized.
Yeah, members, and just real quick, I had been working with the members of the insurance industry on this. This would have been a bill to raise the presumptive medicals in General Sessions Court from 4,000 up, something we hadn't done in a while, but I've been working with all interested parties in good faith. We just haven't been able to come together on an agreement yet, so I'm going to ask that this be taken off notice in hopes that we work something out this summer. So just wanted everybody to know that.
Thank you, Chairman Farmer. Without objection, taken off notice for House Bill 1349. Next up, item number 7, House Bill 760. We got a motion and a second, and we do show an amendment. We got a motion and a second, and it is a late filed amendment. Chairman Farmer.
Mr. Chair, I make a motion we accept the late filed amendment.
We got a second, and okay, so all those in favor for adding the late filed amendment signify by saying aye.
Aye.
Opposed, no. The ayes prevail. And what's that drafting code?
The drafting code is 5128, Chairman.
That's what I show too.
Motion on amendment.
We got a motion and a second. All those in favor for adding 5128 to the bill signify by saying aye.
Aye.
Opposed, no. Amendment added. All right, Chairman Eldridge, you are recognized.
Thank you, Mr. Chairman. This bill just simply adds the waives the lifetime enhancement carry permit fees for state residents who are retired veterans of United States Armed Forces. What the amendment does is, it just confirms they have to be a retired veteran of the United States Armed Forces and a resident of the state on the date of application, and it also changes the effective date to January 1 of 2024 to give the Department of Safety a little more time to upgrade, and they are okay with this amendment. So that's the bill, Chairman.
Very good. Question's been called. All those in favor by sending House Bill 760 to full civil signify by saying aye. Aye. Opposed, no. Full civil. Next up, item number 8, House Bill 987. We got a motion, and we do have a second. Representative Beck, you're recognized.
Thank you, Mr. Chairman. And I am glad I came early in the rotation here so that I can take my hat off. It's giving me a headache. But I do appreciate the sentiment. This bill is very simple. It's brought to me by my senator and constituent. And what it says is that upon the ruling of the Board of Judiciary, concerning a complaint, that the complainant shall be given a written notice of the board's findings and facts, and then also the complainant shall have the same appeal rights to the Supreme Court. With that, Mr. Chair, I renew my motion.
Thank you. Any questions for Representative Beck? Seeing none, we'll be voting for House Bill 987 to send to civil full. All those in favor signify by saying aye. Opposed, no. Congratulations, civil full.
Thank you, Mr. Chair.
Happy birthday.
Committee, thank you.
Next up is item number 9. It's been taken off notice. And we're going to row item number 10, 2 spots. Next up is item number 11, House Bill 570 by Representative Carringer, and that's been taken off notice. And number 12, House Bill 37, off notice. That brings us back to item number 10, and we're going to roll that 2 more spots. Next up is item number 13, House Bill 746. Do I have a motion or a second? Motion or a second? Motion to roll to the hill has been proper motion, proper second. All those in favor signify by saying aye. Aye. Opposed, no. Roll to the hill. Next up is item number 14, House Bill 1507. Motion. We got a motion. Do we have a second? We got a second. We don't have a sponsor. Number 14. We got a motion and a second. All those in favor signify by saying aye. Aye. Opposed, no. No. No's fail. What?
Mr. Chairman, I move that we roll this to first calendar part.
Wait a minute. The sponsor did ask to roll to the hill, and I need to reconsider my actions because it's documented right here. So we do need to roll this to the hill. So without objection, we'll roll this bill to the hill. My apologies. That. Okay, that brings us back to Chairman Hawk's bill. Without objection, we'll roll that bill to the hill, and that is House Bill 606. Next up, item number 15, House Bill 1162 by Chairman Todd. We got a motion and a second, and Chairman, I'm showing you got an amendment. Would you like to read that drafting code?
It is 6035.
6035, that's what I'm showing. We got a motion and a second. All those in favor adding 6035 to 1162 signify by saying aye. Opposed, no. The ayes prevail. Chairman Todd, you're recognized.
Thank you, Mr. Chairman. This bill is the Revised Uniform Arbitration Act, and it replaces current arbitration law that was drafted in the late 1950s and has been in place in Tennessee since the early 1980s. It replaces the law, that law with a revised uniform version that has been updated to meet modern needs and addresses procedural issues now included in the original Arbitration Act. Some form of this bill has now passed in 22 other states, and the amendment does make the bill, and I'd be glad to offer further explanation, but it simply updates and changes arbitration procedures to meet modern needs.
Thank you. Any questions for the sponsor? Representative Beck.
Yes, sponsor, it's my understanding that this has been approved by the Tennessee Bar Association and that all stakeholders have been brought to the table under an agreement. Is that your understanding?
And you're welcome to talk back and forth.
Thank you, Mr. Chairman. Yes, sir. It is my understanding. They've been working on this for a number of weeks now and feel like everybody's gotten real comfortable with it. They've added some language and changed some things, and that's what this amendment represents.
Very good. Thank you for the bill.
All right, seeing no further questions, we'll be voting to send House Bill 1162 to Civil Full. All those in favor signify by saying aye. Aye. Opposed, no. The ayes prevail. Civil Full, congratulations. Members, we're going to reconsider actions and call House Bill 606 up. All those, do I have a motion and a second? We got a motion. Do we have a second? Second. And I show in a late filed amendment. Do you have a drafting code?
Thank you. Thank you, ladies and gentlemen. I do have a drafting code. It is Tracking code 5513.
That's what I showed. Let me see if we can get a motion and a second on the late filed amendment, and then we'll get a description of the amendment. Chairman Farmer?
Yeah, I make a motion, we accept the late filed amendment.
Okay, we got a motion and a second. Would you like to address what the amendment is, and then we'll vote on it? Okay, we'll vote on hearing the amendment first. All those in favor signify by saying aye. Opposed, no. We are going to hear the amendment. You're recognized.
Thank you, Chairman and members. This bill, House Bill 606, essentially is dealing with what are termed adoption facilitators. In most states, including Tennessee, adoption facilitators and their actions are prohibited. However, enforcement is very weak. So what the crux of this bill is gets at individuals who are facilitating, who are friendly with both adoptive parents and friendly with a pregnant woman trying to facilitate an adoption, which they can cause and charge exorbitant fees in the process. So what this does is trying to put some teeth in the current law to keep some of those bad actors out of the state of Tennessee and taking advantage of our adoptive parents who so desperately want to adopt. In a nutshell, that's what this bill does, Mr. Chairman and members.
Thank you. And we need to add this on, but we've got an oral amendment where we need to do that afterwards. So all those in favor for adding Amendment 5513 to House Bill 606 signify by saying aye. Opposed, no. Amendment added. And Leader Lambert, you're recognized.
Thank you, Mr. Chairman and members. And I've spoken to the sponsor of the bill on this under subsection C3. So under 2934-214, liability of adoption facilitator, C3, it currently reads liquidated damages of no less than the greater of $100,000 or twice the total amount paid to the adoption facilitator. In that sentence, Mr. Chairman, the oral amendment that I would make is to remove the words the greater of 100,000 or twice or. So from the to or would be removed. So the sentence after this amendment would read liquidated damages of no less than twice the total amount paid to the adoption facilitator. And remember, the reason for that is, $100,000 seems arbitrary to me. If somebody was paid $20, I'm not saying that they would be for this, this action that they should not be doing. Someone knows a young lady that's pregnant who is interested in, choosing adoption, and they know a family that's interested in adopting, and let's just say one part or the other gives them a $100 gift card. I would hate to see them be on the hook for a $100,000, guaranteed judgment. So all this does, it just says liquidated damages of no less than twice the total amount paid to the adoption facilitator is how it would read with this amendment.
Thank you. I got a motion and a second for oral amendment 1 to add to amendment 5513. All those in favor signify by saying aye. Aye. Opposed, no. Ayes prevail. And without objection, we'll roll both amendments into one. All right. Sponsor, you're recognized. Any questions? Seeing none, we got the question been called. All those in favor by all those in favor for sending House Bill 606 to full civil signify by saying aye. Aye. Opposed, no. Full civil.
Thank you, Chairman and members, very much for your indulgence.
Thank you. Okay, item number 16 be Road to the Hill. Item number 17, House Bill 237. We got a motion or a second? Seeing a motion or a second? Correction, it's been off notices. Okay, just to be clear, item number 17, House Bill 237 has been taken off notice. That brings us back to item number 13, House Bill 746. We got a motion and a second, and I show 2 amendments.
And it is the second amendment that I'd like to have. It rewrites the bill.
Okay, and what's that amendment code?
amendment code, let me grab that right here, 6047.
That's what I'm showing. We got a motion and a second on the amendment. All those in favor for putting 6047 on to 746, signify by saying aye. Opposed, no. Amendment added. And Representative Barrett, you're recognized.
Thank you, Mr. Chairman, members of the committee. Full disclosure, this bill was subbed in the Senate, and what we've done, though, is with this amendment, we're rewriting the bill that was presented. This really pares this bill down to one single issue that we're addressing, and that's just removing the criminal portion for carrying a concealed weapon into a business or a government facility that's posted. All of the other remaining portions of that statute with regards to being able to post your business, prohibit guns from coming on, you're still allowed to do that. It just makes it where people are not being criminalized for walking across the threshold of a business.
Thank you for that. And you're wanting to move forward even though it's general subbed in the Senate?
Yes, Mr. Chairman, if that's the will of this committee.
Okay, we do have some testimony. We'll go out of session and hear from the Department of Safety.
Thank you.
Thank you. And if you'll just come up and identify yourself, and you got 3 minutes. Thank you.
Elizabeth Stroker, Legislative Director and Assistant General Counsel for the Department of Safety. Wanted to clarify, and it may take y'all's legislative legal to confirm with me, but it is my understanding that the bill doesn't only remove the offense for carrying somewhere that is posted. It also does not allow a place, private, state, business, to be able to prevent someone who has an enhanced permit from carrying into their facility. It still has that language in it, is my understanding, from the initial amendments, but I could be wrong, but Section 3, it is still saying that posting doesn't apply, but it's only specific to constitutional carry and the concealed carry permit section. It does not say that it doesn't apply to enhanced, which means it's my legal opinion that someone with an enhanced permit would be allowed to carry even if somewhere is posted. And that is our biggest concern.
Thank you. Any questions for safety? Seeing none, we appreciate you being here today. And while we're out of session, if legal could just clarify where you can and can't and what you can carry into certain locations. And then legal, you're recognized.
Michelle Fogarty, Legal Services. Section 3 of the bill rewrites 3917, 1359, A2, which currently says that the prohibition in subdivision A1 applies to any person authorized to carry a firearm by authority of 3917, 1351, which is the enhanced handgun carry permit statute, or 3917, 1366, which is the concealed carry permit. It says that the prohibition and the restrictions of posting apply to those persons. Section 3 of this amendment states that the prohibition would only apply to persons who are authorized to carry under 3917, 1307G, which would be what was referred to as constitutional carry, or 3917, 1366, the concealed carry. So it does leave out the enhanced handgun carry permit holders, which leaves open that the interpretation that they would be allowed to carry anywhere that, even if it is posted. That would include your state buildings, the Capitol, any private business that's posted.
Thank you. And Representative Beck?
To legal, what would be the remedy then if someone comes on my private property if I have posted properly under the law? What would be the remedy to the landowner of the person coming onto your property?
The bill removes the criminal penalty, other than asking them to leave. The amendment removes the criminal penalty under the posting statute.
Representative Beck?
Would they still be trespassing if they came upon your property armed when you're posted, no arms?
Legal, you're recognized.
I believe you have to ask them to leave first.
Okay, so I would have to ask an armed person to leave my premises, and then if they did not leave, then they would be trespassing.
And you're welcome to go back and forth, so I don't have to recognize you.
I believe so. If they refuse to leave your private property after you've asked them to.
So, okay, and so there's no no penalty or repercussions unless you ask them to leave your property and then it's trespassing.
The amendment removes the criminal offense that's currently in the posting statute.
Thank you.
Representative Parkinson. Oh, thank you. Any other questions for legal? And Representative Grills, you're recognized.
Thank you, Mr. Chairman. I was just curious. Safety said they were against the bill, but I'm trying to figure out how that would affect the day-to-day operations with the Department of Safety, and these are private businesses and private property. I'm trying to figure out what that would be.
Would you like safety to address that?
I would love to know.
And Elizabeth, if you'll just identify yourself again.
Elizabeth Stroker, Legislative Director. Michelle can correct me if I'm wrong, but it would apply to state buildings, so it would allow people to carry into our state buildings.
And y'all are welcome to go back and forth.
Well, you don't want us to do that.
We're always cordial.
Yeah. So which state buildings would that be? Courthouses or just Tennessee Tower?
It would be literally any state building that is owned or leased by the Department of General Services. So any Department of Safety building, DL Center, THP Post, any Department for Children's Services, Department of Corrections, TDEC, mental health, hospitals, health. I mean, it's literally everything.
Do those buildings have a process now by which that people can carry, or are they prohibited totally?
It is prohibited, except for law enforcement.
Okay. Except for law enforcement?
Correct.
On-duty law enforcement?
In certain situations.
On-duty law enforcement or just law enforcement?
I need to check on that. The law enforcement codes are in a different section. I need to look at it, but I think it's anytime. I believe this body fixed that either last year or the year before so that it was law enforcement could carry even off duty. But I'd need to confirm with that, or if Michelle has it in front of her, she might know.
Okay, so I guess an off-duty police officer acting as a private citizen could carry into one of these prohibited places?
I don't know the answer to that. I would need to check on that.
That's fine. That's fine. We can talk about that later.
But
Thank
it would
you.
apply to anyone else wanting to carry in those buildings.
Thank you.
On my commission card, it said on and off duty can carry anywhere. So. And Representative Parkinson.
Thank you, Mr. Chair. I was just trying to make sure I heard right. Did you say Department of Corrections? They could carry in the Department of Corrections? So prisons?
Representative Stroker.
Thank you
Ms.
for that
Stroker.
upgrade. I don't know if y'all would want me to come join y'all up there, but
Probably a better place.
yeah, I'll let Commissioner know you said that. I'm sure he'll love it. So I'd have to defer to corrections, but I think they have federal prohibitions for prisons, but it would apply to any other facility where somebody could be housed under Department of Corrections.
And y'all welcome to go back and forth.
Okay. And so no state prisons, and what about jails, local jails?
I'm not sure. I don't know if that falls under the federal prison system, but if it's a state or private building, then potentially you could.
And unless they change things, law enforcement cannot carry behind the bars of a local jail or state prison.
Right.
And even the corrections officers can't carry any kind of firearms inside the penitentiary. So, Representative Parkinson.
Thank you for that, Mr. Chair. But how does this bill affect that, like for local facilities? Is that what the chairman was quoting? Was that federal law, or how does this bill affect all of that?
I don't know how it would impact your jails, your local areas. It could very well allow people to be able to carry into the jails. I don't know how that plays for the federal prohibitions as prisons are.
Okay. Thank you, Mr. Chair.
I'd say if y'all could find Jimmy, he may could answer, but I think he's down in Senate.
Okay. Thank you.
All right, seeing no further questions, we'll go back into session here from the sponsor. And the sponsor, you're recognized.
I'd just like to point the committee to subsection G of 1359, which provides for a whole host of exceptions to this bill, this law. This law does not change anything under those exceptions. You're still limited to where you can carry in all those same places. You can't go into school buildings. You can't go into parks. You can't go into all the places that are listed in subsection G. We're not changing that. All this bill is going to do is make it where if a person who has a legal right to carry down the sidewalk, walking down a shopping center where there's 14 different stores and 2 of them are posted, they're not being criminalized just by walking into a store with their concealed carry on their hip. It also for all the concern that we have about people leaving their guns in their cars, this is going to reduce that, because now you're not going to have to walk all the way back to the parking lot, put your car in the glove box, or your gun in the glove box, and leave it there in order to go back in the store with your wife. All we're trying to do is protect law-abiding citizens who've done everything they're supposed to do by going and getting their permits, their enhanced carry permit or their regular carry permit, or that are following the law that says you have permitless carry, from being charged with a crime simply for walking through the doorway of a building.
Representative Bolzo, your recognition.
Thank you, Mr. Chairman. It seems to me, Representative Barrett, that this proposed legislation does more than that. When we're looking at Section 3 of Amendment 6047, Council has just confirmed for us that someone who has a carry permit pursuant to 39-17-1351, which is an enhanced carry permit, is no longer subject to the prohibition regarding carrying a firearm into a public building. So, based on this language and on the guidance we've received from Council, this bill does more than just remove criminal penalties from someone who might accidentally stumble into a facility that's posted. What is your response to what we've heard, that your bill does more than just remove criminal penalties? It actually now allows someone with an enhanced carry permit under Section 1351 to carry into public buildings.
And y'all are welcome to go back and forth.
Thank you, Mr. Chairman. Thank you, Representative, for the question. The situation is no different than is currently under the law. The businesses and/or government buildings can still be posted. So you still have the same warning signs that are being put, all the same limitations that are in the law currently about how those signs have to be, what has to be on them. And it's just as legal presented to you all. Anyone can be asked to leave a private business or a government building, and if they refuse to do so, they can be charged with criminal trespass. So that part has not changed. Nothing changes with regards to the business owner's ability to control their personal private property.
Let me ask it a slightly different way. Right now, when we look at Section 1359A2, it includes someone who has an enhanced carry permit pursuant to Section 1351. That portion of 1359A2 is being removed. Why is it being removed?
It's not being removed. If you'll notice, we're dealing with A1A. There's an A and 1 and a 2. You're talking about two different things. The enhanced carry is addressed in subsection B of subsection 1, I believe. So they're treated separately under this statute. Enhanced carry is treated separately. There's 1A that is a prohibition and 1B that is a restriction as to enhanced carry.
Representative Bolzo, any follow-up?
I'm just studying just for a second. We've got multiple sections and moving parts here.
Leader Lambert.
While counsel down there studying, and I'm with him, I have some questions here. Just kind of as a basic question. So when dealing with private property rights, I mean, the reason this is structured the way it is now is that we've always respected the fact that if someone owns their own business, that they can say no shoes, no shirt, no service. And quite frankly, I mean, the Second Amendment protects us all from our government infringing upon our rights. So what protection would a private property owner, I mean, if, you know, my business, my little law firm, I mean, if I, for whatever reason, tell someone that I would like for them to leave under the trespass statute, they have to. So what kind of interplay would this have with that, and what rights would a private property owner have if someone comes into their business, disregards the sign, and just says, look, I don't care if it's your property, your business or not, you know, that they're going to carry their firearm in there? I mean, what rights would a private property owner still have?
And you're all welcome to go back and forth.
Thank you, Mr. Chairman. The situation is no different. If I were to walk into your law firm with my firearm on my person, and you had it properly posted, and you saw that firearm on my hip and asked me to leave, then, and I refuse to do so, then you can swear out a warrant to have me charged with criminal trespass. The only difference is by me walking in, if I walk in and do nothing and you never see it there, I'm not subject to penalty for a crime. It's the same thing, though. You would have to see that on my person, realize that I had a gun on me anyway to charge me with this penalty under this statute. So all it is whether or not I'm getting charged with criminal trespass or I'm getting charged with criminal trespass and a Class C misdemeanor, I believe.
By the way, the only thing on that side of my law firm is, I think, an NFIB member sticker. So we don't prohibit firearms in our law firm. But at the same time, I just want to make sure there's still some remedy there that a private property owner would have, because it is their property. I mean, they pay the rent, they pay the mortgage, they own it. It is their property. And while I firmly believe the Second Amendment should be, extended as far as humanly possible to protect our rights from our government infringing on our property, I do not think the government should be infringing upon our private property rights either. So I think this in the past had been structured the same way as trespass laws, because if I've posted my property no trespassing, that means you can't come on my property, period. If you do, then you've committed a trespass. So, I know it's gen subbed in the Senate. I don't see the harm in going a little farther on this, but I did just want to go ahead and get that on the record that if, a private property owner asks somebody to leave for whatever reason, there's nothing we're doing here that would prohibit them from doing so. Is that fair enough?
Correct.
Thank you.
Chairman Todd.
Thank you, Mr. Chairman, and I do like the tenet of this bill. I like the protection that you're putting in. We're maintaining protection for private property owners, even though, and for the record, as you well know, private property owners, by putting out a shingle and saying I'm open to the public, are now public conveyances by law. So they have private property rights, but they also have responsibilities under public conveyances that put some of that in check. So we just always have to keep that in mind. Thank you.
Thank you. Representative Grills, you're next.
Question on the bill.
Question's been called. All those in favor of sending House Bill 746 to full civil signify by saying aye. Opposed, no. Civil full. Congratulations.
Thank you.
Okay, committee, that brings us back to item number 2, House Bill 1346 by Chairman Farmers, running for Representative Powers. We got a motion and a second, and I do not show any amendments. You are recognized, Chairman.
Yeah, thank you, Mr. Chair. And what this does, it just relates to private property rights to cities and counties, and anything that would be adverse to those property rights. This would protect those. Anything with regards to any policy recommendations originating to the Agenda 21. So that's Representative Powers' bill, and I'd ask for passage.
Thank you. Any questions? Seeing none, Representative Parkinson.
So what is Agenda 21 again?
That's a great question for legal.
We'll go out of session, hear from legal.
If you don't, Mr. Chair, thank you.
Legal, you're recognized, and you're welcome to go back and forth for follow-up.
Okay.
Michelle Fogarty, Legal Services. Agenda 21 is an action plan by the United Nations with regard to sustainable development.
That's what I thought. Thank you.
Okay, without objection, we'll go back in session. Seeing no further question, we got a questions called. Send House Bill 1346 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Next up is item number 16, House Bill 1351 by Chairman Farmer. Do I have a motion? We got a motion and a second, and I do show an amendment, Chairman.
Thank you. Thank you, Mr. Chair. That's did you just call up House Bill 1351?
I did, and I just need the drafting code for your amendment.
Thank you. And I'd like to move. Excuse me. Yeah, 6271.
That's what I'm showing. We got a motion and a second for 6271. All those in favor for adding 6271 to 1351 signify by saying aye. Opposed, no. Amendment added. And you're recognized.
Yeah, I think, Mr. Chair, sorry about the confusion there, committee. I had 3 or 4 bills here. I know that's that time of year. What this does, members, is elected sheriffs across our state are required to carry a bond in case something happens with one of their deputies. Currently, there is no statute of limitations in place for a cause of action to be filed against the sheriff, him or herself, with regards on an action against that bond, trying to attack it and collect on it. So what this does is just set into law with with how our other statute of limitations are. We're going to put a 1-year statute of limitations on that, a 1-year statute of limitations. So doesn't delete the cause of action, just allows for that 1-year statute of limitations. That's all it does.
Thank you, and I appreciate you working with the sheriffs and everybody to get this in order. And Representative Grills, you're recognized.
Thank you, Mr. Chairman. So, Chairman Farmer, you said this had, there was no statute of limitations before this bill?
And y'all are welcome to go back and forth.
Yeah, Chairman Grills, that's how I understood it. That's the way the statute read, so.
Do you have any idea about the amount of dollars this will save a county across the state or counties across the state? I can only see it being a benefit financially to them.
You're welcome to go back and forth to follow up.
Thank you. Yeah, I'm sure that I'm sure there's a cost savings with it. I'm not certain on exactly how much that would be, but I think when we're looking at this, let's just look for a good policy that we don't want something hanging out there for 5 years and somebody just trying to make a quick buck. But they have 1 year. It's a good amount of time, but I'm sure there'll be a cost savings.
Well, I think it's a great idea. Appreciate you for bringing it.
Thank you.
All right, Representative Bullslow, you're recognized.
Thank you, Mr. Chairman. Chairman Farmer, my question is about Section 1C2 of the bill. I see that in B, we're adding a 1-year statute of limitations, and I understand that. In C1, we're saying that the county has 60 days to answer or otherwise respond to the lawsuit that's brought within a year. I understand that. We look at C2, it says, quote, a claim is deemed to have been denied if at the end of the 60-day period the county has failed to approve or deny the claim, close quote. I'm not sure I understand what that means, and in context, it doesn't seem to fit with subsection C1. Are you able to provide some guidance as to exactly what C2 means?
And y'all are welcome to go back and forth to follow up.
Yes. Let me take a shot at this. If not, I'll defer to legal. C1 basically says you have 60 days to answer, allows the county to answer or respond within that 60-day period. C2 says a claim is deemed to have been denied if at the end of the 60-day period. So if the county takes no action, then the claim's denied. Okay. One moment.
Okay.
Would you like to go out of session to hear from legal?
Yeah, please.
Okay, without objection, we'll go out of session. And legal, you're recognized.
Michelle Fogarty, Legal Services. That language is identical to language in the Government Tort Liability Act in 2920-304, where a government entity or employee has 60 days in which to answer or otherwise respond to a claim, and then the claim is deemed to have been denied if at the end of the 60-day period the government entity or its insurance carrier has failed to approve or deny a claim. As far as intent, I can't speak to that. I can just tell you that the language comes from 2920-304.
And the language that you're referring to in 2920-304, is that a claim and an approval process that precedes the filing of an actual lawsuit under the GTLA?
That's the claims procedure for the GTLA.
Yeah.
Yes. Mm-hmm.
All right.
Yes. Yes, you have to give them notice.
Can you, Michelle, provide some clarity as to what this language is doing here? Because it seems out of place. As written, someone has a year to bring the case. The county then has 60 days to file an answer. What is C2 doing here? What does it mean? There's no claims process here the way there is in GTLA. This is just modifying the statute of limitations.
I assume it's just like a no savings clause. if no answer is filed, the allegations are deemed denied. I mean, that's my best guess.
Okay.
You
But
know.
obviously, we know that under Rule 8 of the Rules of Civil Procedure, that's not true. So my only question, Chairman Farmer, is that, like,
We'll go back in session, so you can ask
sure, I'm
Chairman
sorry.
Farmer. So without objection, we're back in session. And Representative Bolzo, you're recognized.
Yeah, my only concern, thank you, Mr. Chairman. My only concern, Chairman Farmer, is that, like Chairman Grills, I agree that it's good to put in a statute of limitations, provide clarity, give 60 days for the county to respond. But C2 makes no sense to me. And I'm concerned that if this bill passes the way it is, this subsection C2 could cause some mischief because I don't know what it's doing here.
Chairman Farmer, you're recognized.
But I think it's important to look at this. Let's think about this for a second. A claim is deemed to have been denied. That's not a default. That's not an end-all, be-all. So that's just saying, look, we're denying this claim. Move forward with your suit, right? I don't practice a whole lot of GTLA work. I think I've handled one in 15 years. And that was probably 13 years ago. But so once a claim's been denied, right? What are the next steps under the GTLA? I guess that'd be the question, right?
And legal's got us.
That I don't know.
Yeah, legal's got us an update too. So we'll go back out of session real quick and hear from legal. Legal, you're recognized.
Michelle Fogarty, Legal Services. I'm assuming it's so that there can be no default judgment against the government, that if the government doesn't respond in 60 days, it's deemed denied, and as you said, that it proceeds. So there could be no default judgment against the sheriff in this case. That's my best guess.
But as I understand, Title 8, I think the sheriff is immune. That's why the case is being brought against the county, not against the sheriff.
I'm sorry, the county. But,
okay.
Yeah.
That's fine.
Without objection, we'll go back in session. Any other questions for the sponsors? Seeing none, we'll be voting to send House Bill 1351 to Civil Full. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes prevail. Okay, that brings us to item number 14, House Bill 1507. And the sponsor's not here. So no motion, no second, bill fails. That takes us to the special calendar. Item number 18, House Bill 795 by Representative Capley, and I think we're going to take that off notice. It'll go back to the clerk's desk. And Chairman Farmer, you're recognized.
But, Mr. Chair, and thank you for that. Before I make a motion to adjourn, subject to the call of the chair, I believe that concludes our calendar. I just wanted to take a moment to thank you. I think it'd be appropriate for all your hard work and leadership in this committee. I've served under a lot of chairmen, Chairman Lamberth and some others, but I will tell you that you've done an excellent job. Appreciate your leadership and all you do for us committee members and having our back and working with us on our bills, those on this committee as well as those others. And just want to thank Speaker Sexton for giving us the opportunity to have you as our chairman. So I want to thank you.
Thank you. And I didn't pay him anything to say that either. So, but I want to thank each and every one of y'all. It's truly an honor to serve alongside each one of you, our staff here. I couldn't have done it without each one of them, even though sometimes I can't get their names right. But anyways, we do. We've got hats to party after a while. So, like I said. Absolutely. So seeing no further business without objection, we stand adjourned, subject to the call of the chair.